Welcome to the Tough Decisions Network for Entrepreneurs. I'm Dan Hanford, and my wife, Danae, and I interview successful people sharing stories behind tough decisions that they've had to make along their journey as an entrepreneur. Before we get started, let's hear from one of our sponsors. Have you ever thought about investing in real estate, but find yourself so busy that you don't have time for it? Do you have FOMO, which is the fear of missing out? At HanfordCapital.com, we help investors with passive real estate investments that project better returns than traditional investment vehicles such as the stock market. If you'd like to find out more about our passive real estate investments, visit HanfordCapital.com. That's HANDFORD Capital.com. We will jump on a call with you to discuss your investment goals and to see if our investments are a good fit for you. This advertisement is not to be construed as an offer or recommendation to buy or sell a security. Visit HanfordCapital.com. On the podcast with us today is Richard Chapo. He is a business lawyer out of San Diego with a company and a website called SoCalInternetLawyer.com. Well, Richard, thank you so much for being with us today here on the podcast.
Thank you for having me on.
I want you to get us started and talk to us a little bit about your background and where your current focus is right now in the space that you're in.
Sure. I've been practicing law for, going on 25 years. My initial focus being in San Diego was doing litigation defense work for about a decade. After that, went to Russia, of all places, for about a year and taught at the university, and then came back and got into what at that time was the new field of internet law, which is really just kind of a collection of different laws, but as applied to the online environment. And since then, I've been doing that. And I work with companies, large and small, entrepreneurs, people of that sort who are getting into the online environment and trying to grow their businesses while minimizing, the legal risks that they face.
Mm-hmm. So obviously, I think one of the biggest topics right now is about privacy. There's a lot of law that's being written and enacted, and not just here in the States, but also across the world and like the European Union and things like that. I think the most misunderstood is the GDPR, and I know you're not a European Union lawyer, but I know stateside we're all having to cover ourselves with that because there's some scare out there as to what might happen if you actually have somebody unbeknownst to you that's from the European Union actually coming to your website and you're not following those same practices.
Right. Yes. The GDPR went into effect on May 25th, 2018. It was the first big privacy update as applied to the online environment, although it also applies offline in the European Union since 1995. So as you can imagine, the web has changed just slightly since 1995. And
just a little bit.
Yeah, this regulation the idea was basically to try to reflect those changes and also predict a little bit of the future and to try to move the power of who controls personal information away from businesses and back into the hands of consumers. To the extent that it does that or not, or it meets those goals is somewhat questionable, but at least that's what they're heading for it. And the basic idea behind the GDPR is that you need a legal basis to collect information, what's called personal data, from individuals who are located in the EU. The law's, it's actually a regulation, is written in some confusing terms. It's not well written from a technical legal perspective. So a lot of people think it applies to citizens in the European Union. That's not correct. It applies to people located in the European Union. And so that opens up some interesting, concepts for people to think about filtering and what have you, because you can look at IP addresses and so on and so forth. But the bigger issue with the GDPR is there was a real question that once it was enacted, was this going to be kind of a standalone situation just in the European Union because privacy is viewed a little differently there than in other parts of the world? Or would it be a concept that would start moving across the world and be replicated in other areas? And what we've seen pretty shockingly is that it's already being replicated in California, which means that U.S. businesses, even if they were considering ignoring the GDPR, because there are some legal basis for doing that, if you have clients in California, and most U.S. businesses are, there's another similar law that you're going to have to take into account anyways. And so the idea that, privacy is the power and privacy, if you will, at least is being switched back to the consumer, is something that looks like it's going to replicate.
So what is the legal basis that you're referring to or that the GDPR refers to be able to collect that personal data? So obviously I've been into some websites, since that was enacted in May 2018, our MailChimp or our Contactually that we use for, our CRM database. And, when we first went there after it was enacted, there's all these buttons and things you got to click and say yes and approve and all that kind of stuff. So what is it in the GDPR that actually says qualifies for that legal basis?
Right. So there's an article that addresses it, and I believe there's 7 of them. However, 3 of them are really inapplicable because they deal mostly with government agencies. The first most common one is consent, and that's what you're seeing all over the place, which is you have to get affirmative consent from somebody before you can collect their personal information. And so you'll see this when you pop onto a website. You often see the cookie notice pop up and asking you for consent. And that's what they're trying to do. One of the problems with the GDPR is it's not well thought out from a practical standpoint. So personal data is defined really broadly. Pretty much anything that you can directly or indirectly use to identify somebody. And so if you think about that, that's like an IP address. Okay, well, in the US, an IP address really generally isn't considered personal information. But in the EU, it is. Well, as soon as somebody visits a website, one of the things that the servers on that website almost always automatically collect is the IP address. And they're collecting that for a variety of reasons. So the question practically a lot of people face is, well, how do I get consent before I collect that? Because GDPR requires that. And it's kind of an ugly mess right now, but that's why you're seeing the cookie pop-ups. And then if you want to, join a mailing list or anything of that sort, you're seeing these pop-ups again. The interesting thing about consent is it's not really actually favored under the GDPR. It's kind of considered a last resort legal basis. And the other thing that people don't understand is that consent is not permanent. It decays over time. And so what that means is, if somebody signs up for your email list, how long is that consent good for? Well, under the U.S. business model, the goal has been to, just build a list of people ongoing and, keep mailing them forever. Well, under the GDPR, you can't do that. You have to actually go get subsequent consent again and again and again. And then the question that comes to everybody's mind at that point is, okay, well, how long is consent good for? And the various enforcement agencies and the Article 29 Working Party haven't really given much guidance. Article 29 Working Party, the group that actually wrote the GDPR, said it's good for, quote unquote, an appropriate amount of time. Yes. Well, you laugh as a lawyer, I cry. So it's, you get into that kind of a thing. The other legal basis and the other 2 really deal with the contract situation. So if you have a situation where, you're collecting information as part of a contractual transaction, and then you can collect that. You don't need consent. You can just collect that as part of the transaction. It's a legal transaction. The third one is if there's legal duty. So let's say, for instance, under the Digital Millennium Copyright Act in the U.S., if I'm a website and somebody submits a DMCA complaint to me or a subpoena or something of that sort, I have to produce the information of the person who's using my site. Well, that's a legal obligation. And so in that situation, I don't need consent from the person under the GDPR. I can just go ahead and produce that information. And then the last one is, and this is kind of an example of just how messed up the GDPR is, it's something called a legitimate interest. If there's a legitimate interest on behalf of the business and that outweighs the fundamental privacy rights of the individual. Now, if that's sounding like it's incredibly vague, that's because it is. There's literally, it's, you get this mumbo jumbo. And so a lot of people are saying, okay, well, what does that mean? And there are different balancing tests, and you have the 28 enforcement agencies. Each country, each member state has their own enforcement agency, all putting out different guidances as to what that means and doesn't mean. But it's really a case-by-case analysis, and it's just, kind of a mess. And then you get into, other problems with that and some of the guidance that the Article 29 Working Party, put out. They said, for instance, in a footnote in one of the recitals, so the GDPR consists of 99 articles, and then there's 273 recitals. The recitals are the Working Party trying to explain what they meant in the articles. And there's a footnote, and yeah, exactly, yes. And if you look at the 20 biggest companies that deal in the online environment in the world, how many of them are located in Europe? None. And this is the reason why. Europe is so heavily regulated that it's just impossible. But anyways, there's a footnote in one of these recitals that says, direct marketing may be considered a legitimate interest. And so all of us, raised our hands in glory and thought, woohoo, here's our loophole. Here's how we get through this mess. But now there's a new regulation coming out called the e-privacy regulation in Europe that will deal with email marketing and things of that sort. And they're going to basically shut down direct marketing as a legitimate interest. So nobody's really sure what legitimate interest means. As an attorney, we just kind of put together a balancing act and make sure you have some kind of an argument so you can at least make that argument with the enforcement agencies. But so basically those are the four legitimate interests, or the four legal basis for, going ahead and collecting data and using it in your privacy policy and your disclosures. You need to be much clearer about, how data is being collected, who you're sharing it with, and then the rights of the individuals. So individuals have the right to change their information. There's a whole list of things to have information deleted. And it really comes down to kind of a fundamental difference in the view of privacy. In the United States, where I'm located, where you're located, privacy, we like to talk about freedom and this, that, and the other, but our privacy laws are pretty much a joke. We don't really even have any. The best that we have on the federal level is we have some privacy laws for specific situations, such as health records, with HIPAA, or with, in the online environment. If you're collecting information from anybody who's under 13 years old, we have a law called the Children's Online Privacy Protection Act, and that sets forth parameters about how that can happen. But as far as a general privacy law, we just don't have one. We don't value privacy here that way. If you look in the Constitution, the U.S. Constitution, privacy isn't mentioned. Now, courts have interpreted it as a fundamental right in the Constitution, and you get into areas like abortion and that kind of stuff that we really don't want to talk about. But it's that kind of viewpoint. In Europe, with the European Union, privacy is one of the fundamental aspects of their charter. So it's treated much stronger, much more valuable, like one would free speech over here. And so privacy is considered, much stronger. I always use one example to give people kind of an idea of the different view of privacy. In France, if you have a family, you have kids, let's say your kids are 9 and 10 years old, you have a birthday party and you have family all over the country. So you go to Facebook and you post images of your kids at the birthday party. And in France, you've just broken the law and you're guilty of a misdemeanor. You can be fined up to, I think it's 5,000 francs, or go to jail for a year. And the reason for that is you violated the privacy rights of your children.
Wow.
Yes. So in that situation, the state is setting the standard for what they think is best. Whereas if anybody tried to do that in the U.S., they would be tarred and feathered and, left out on the border of town. So it's just a different mentality as to how people view privacy and what have you, and are these companies that are, frankly, using these data strategies, are they evil or are they not evil? The EU was set up for a number of reasons, but one that people seem to forget is it was set up to compete economically with other, large economic powers, including the United States. And they hate Google and they hate Facebook, and they're always going after them. And in some cases, I applaud them for doing so. But, there's a certain predatory nature of the GDPR as well. So there are a lot of different factors to look at it, but it's definitely a revolution in privacy law.
So the GDPR, what's the difference between the GDPR, which is the European Union one, versus the DMCA, which is the Digital Millennium Copyright Act that we have here in the States? That's been kind of antiquated as well, because it's back in the late 90s when that was done. But
right.
What's the difference between the two of those?
Well, the GDPR is really privacy and data protections, and the DMCA is copyright.
Got it.
And in the United States, it's the United States federal law. And basically what happened was in 1998, as hard as this is to believe, the federal government wasn't actually, brawling with itself. And they passed a number of different laws that were designed to try to create protections for, at that time, a very young internet that would allow, businesses to grow without getting just, basically crushed by a wave of lawsuits. And one of the obvious things that came up in the online environment was, copyright infringement. How do we deal with these situations? If you think before the internet, for somebody to commit copyright infringement was kind of difficult unless, they really intended to do so. If you went out and you wanted to copy and resell a book, you had to go copy all the pages and do this and that and the other. Well, once the internet pops up, it's right click, copy and publish. And you see, this burgeoning sharing society, this sharing world where we have people sharing images right and left, and companies not only are not trying to protect their intellectual property, their big goal is for you to share it. So how do you deal with copyright infringement in that kind of environment? And the DMCA was created to try to do that. And for the most part, despite all the criticism, it has worked. There are definitely some serious problems with it. But for listeners who aren't familiar with the law, basically what it says is, under what's called Section 512C, if you are a passive internet platform and you have users that post something that infringes on the copyright of another person, another party, you, the website platform, cannot be held liable for copyright infringement so long as you follow a particular compliance process. And the compliance process is pretty basic. And so the idea is that, well, can Facebook look at, the 1.4 billion users or however many it has and everybody posting to the site? Can they filter and control that? Well, now they may be because they're so huge and they have so many resources. But when they first started out, no. And it would have just killed their business. Same thing with YouTube and all these different groups. And so that immunity was created. Now, when we contrast it to give you an idea of, again, how the world's kind of splitting up and the internet is splitting up. Right now in the EU, they're going in a different direction with copyright law. And what they're saying is that platforms that have, quote unquote, large amounts of data, again, what does that mean? Will now have to filter all their content. So they're not going to the DMCA route. They're going to require companies to actually monitor and filter all of that, which for people who are creating content is probably a good thing. But it's the end of memes. You're not going to see, a lot of the sharing is going to be dead because these sites, because now they're going to be liable, they're not going to allow you to post that. Why should they take the risk? The second thing that we're seeing is there's another chapter of the new copyright law that will have a link tax. And so if you link to any content from a news organization, you will have to pay a tax on that link. That's ultimately in the real world, it'll be a licensing fee, but that's the kind of whole new concept. And the question then is, okay, well, how do you deal with journalism? How do you fund it? These kinds of things. And so in the EU, they're going in that direction. In the US, they never really would. But you're seeing these different breaks. So the DMCA is, an incredibly important law in the US. And it is, again, it has a lot of problems with it. But from a foundational aspect, it's probably one of the reasons why we have a fairly vibrant internet, as well as, a couple other federal laws that are out there that are a little more esoteric.
So let's pivot here and talk about how to best comply with these laws. Because, we know they're there now. So we know what they are. We've been clarified that. Kind of all the different, crazy nuances that are in there and the vagueness of it. But what's the best way to comply with it? Because I feel like sometimes we look at that and we just kind of put the tail between our legs or put our head in the sand and just say, forget it. I'll just see what happens. So what's the best way for, small to medium to large businesses to really try to start to comply with these types of laws?
Right. Well, unfortunately, at this point, the days of being able to take a form off of the, LegalZoom or something like that are really over when it comes to the online environment. And that's, even though I'm an internet attorney, most of my clients are, bigger. People that are starting a blog, typically wouldn't use me in the past because, funds and everything else. So, although this might sound like it's a boon for me and my peers, the truth is, it's the development of these laws is really difficult and damaging to the internet because people that want to start out, they're going to have to wing it, or they're going to have to go find an attorney, that they have, a budget to deal with. The GDPR, as I mentioned, it's, 400 plus pages. The thing's just a monster. And there is no simple form. There is no, boilerplate you can put on a website and be okay. Now, there is the practical reality that if you have a blog about growing tomatoes and you have 23 visitors every month, are you likely to get enforcement action letter from, the UK? Probably not. But we've just really reached that age where, unfortunately, as I think I mentioned before we started the interview, the empire is striking back. And governments are passing these regulations and law. And, a lot of it's based on the concept that, your average citizen can barely breathe on their own. So the government must step in and take care of them from these different perspectives. So unfortunately, you're probably going to have to use a lawyer. Again, there's a risk analysis to it. One of the things that is also different between the EU and other countries, or states, such as California, is thresholds. So in the EU, unfortunately, they treat, that tomato blogger I just discussed pretty much the same as they treat Facebook. The requirements are all the same, except for a record-keeping provision. And so it's really unfortunate. And again, an example of why people, try to get out of the EU as quickly as possible if they want to start a business. To contrast that, California passed a privacy law. It's kind of jokingly referred to as GDPR light. And it has many of the same provisions as the GDPR, but it has thresholds. And it says, unless, you meet one of these thresholds, you don't have to comply with this law. And the thresholds are, you have $25 million a year in sales. You collect information from less than 50,000 people in a year. So if you have traffic and you're getting 1,000 people or 2,000 people to your site every month, you don't have to worry about it. You don't have to comply. And the third one is you derive more than 50% of your revenues from selling personal data. Now, that's kind of problematic if your business model is to generate leads, because when you're selling leads off to people, you're selling personal information. But other than that, for most other sites, it's not a huge issue. So, in California and with the U.S. laws, there's going to be that threshold there. But for the GDPR, you just have to kind of do a risk analysis and sit down with an attorney. Most attorneys are, offering payment plans at this point because they know how difficult it is for the smaller businesses. But, with all the regulations and requirements, it's just, unfortunately, European laws, there's just no simple answer to them.
Mm-hmm. So let's talk about the ostrich head in the sand mode. Okay. So somebody who's listening, they're like, I think this is too complicated. I don't have the money to hire an attorney. I want to just, move forward and just ignore all this. So what are the consequences for somebody just sticking their head in the sand?
Well, it's an excellent question. And the issue that you face with the GDPR, as well as the California law, is that the penalties are couched as regulatory fines. And regulatory fines are not covered by insurance. So even if you buy a liability insurance policy, it doesn't protect you like it would with normal business risk. So you're kind of out there naked. And the question then becomes, can they enforce it? Which is really kind of the fundamental if we get right down to, the nitty gritty of it. With California law, yes, they can. California Attorney General is charged with levying fines and enforcing the regulation. And if they were to issue a fine in California, they would then be able to get a judgment in other states under something called the sister state concept. Not very difficult. So California, if you meet those thresholds, you definitely want to comply because there's nowhere to run. With the European laws, with the GDPR, now we're into a more interesting area. Because, again, how exactly are they going to enforce those in the U.S.? There are federal acts like the Uniform Foreign Monetary Judgment Act that do allow for the transfer of penalties and regulations and judgments in another country to the U.S. However, it's a complicated law, and the U.S. courts tend to be fairly hesitant to enforce judgments that would not be judgments here. So let me give you an example. When we talk about tax evasion, everybody talks about Switzerland and how Switzerland is, helps people evade taxes and this, that, and the other, and they won't help other countries. And one of the things that people don't really understand from a technical aspect is that the way Switzerland is organized, they don't have a strong federal government. Instead, they have really strong, what would be the equivalent of states are called cantons. And there isn't really an income tax per se, not as we think about it. So the idea of tax evasion, as we think of about some rich person shoving all their money into, trust in Switzerland somewhere, that isn't actually a violation of law in Switzerland. So for the U.S. to claim, income tax evasion and then try to enforce that in Switzerland is very difficult. And so there is a school of thought that the same thing may happen with the GDPR. Particularly when we're in an environment where we have a president who's not exactly EU friendly, and if they try to come in and enforce it, how's that all going to go? I will be honest with you, I don't know. But the potential downside of that is it's going to be very expensive to find out. You're looking at a trial, appeals, everything else, and you have to pay attorney's fees for all of that. Yeah, and so that's that cost. Obviously, you would be barred in Europe. They would just cut you off. Your site would not be viewable. But a lot of people, the mentality of the internet is such that we feel like we have a sort of right to be there. And so people don't really look at it economically. So I think I have my cheesy little, law office website online. And, by God, if a rich oil minister prince in Nigeria really wants to send me $14 million, well, he's got the right to do it. And I've got the right to be there. Now, in the reality, in the real business world, you would look at the economics of being in certain markets, and does it make sense financially? That's where we're headed. You need to look at your website, you need to look at your online business and think about, well, do I want to comply or not? And does it make sense financially? If you have 10 sales in the EU in a year, it doesn't. Why would you comply? And instead, a better option is just to block the EU. You're not getting sales.
Yeah, it's not worth the expense for those 10 sales, depending on what you're selling and what the profit margins are and things like that.
Right. And this is a situation where, for people that have smaller businesses online to look to the bigger guys and see what the bigger guys are doing. And, when the GDPR went into effect on May 25th, a lot of people in the EU were surprised because they no longer could access a lot of websites around the world. The Los Angeles Times cannot be viewed in Europe.
This has just happened back in May of this year, May 25th, 2018. Has there really been any litigation up to this point to see if anybody has been challenging it or been sued for it or anything like that to get the ball rolling?
There's been a couple small ones that dealt with Facebook primarily, but not really. And the reason for that, and that sounds hopeful, but it's actually kind of a red herring. The problem is the member states have to pass budgets to fund the enforcement agencies, and they've got to hire people and get their act together to go after people. So I wouldn't read too much into that yet. I would wait at least another 6 months, and then we'll kind of see what people are going to do and what these groups are going to do. Now, there are agencies in the EU, in a bit of good news, that are they're not interested in penalties. The penalties under the GDPR up to $24 million or 4% of your worldwide revenues. Now, people listening to this, don't freak out. You're never going to get from those fines. Well, you might get the 4%, but not 24 million. That's obviously designed for the Googles of the world. But there are groups like the ICO. The ICO is the enforcement agency in the United Kingdom. Last year, they had something like 17,000 complaints under the previous privacy law. They only issued fines in something like 27. Wow. And the reason for that was that to their credit, they recognized that there were areas where it was difficult to understand the law. It was vague, like some of the things we've talked about. And they issued guidance, and they worked with companies to say, okay, well, here's what we think you should do. And so instead of just, pounding people over the head with a bat, which they had every right to do, they went ahead and took this approach. And I think that that's good. The problem is there are enforcement agencies in other countries that are completely out of control. The French enforcement agency is out of control. The German agency issued 175 audit notices to people before the GDPR was even issued. Wow. And so we don't know the outcome of that. A German court, to give you the idea of how strange all this is going to be, a German court did issue a decision in a case that dealt with Facebook fan groups. So if you're on Facebook, you often will open a group, either to support your business or maybe about a subject or something of that sort. And what the court ruled was basically that if you open that group, because that group can be accessed by people who aren't actually members of Facebook, you're violating the GDPR. And you and Facebook are what are called joint controllers, which means basically you're partners, and you need to have a legal basis for collecting that information, which means more or less in that situation, you have to come up with some kind of consent mechanism and all that.
I would think that there's an inherent consent with that. If you actually were the one that clicked the button to join the group, isn't that like inherent consent, like understood?
Well, and that argument's been made, but we're getting into the bigger issue of personal responsibility. If we go back to the France issue with, posting pictures of your kids at a birthday party, to me, parents have the authority to do that, for better or for worse. You would like to think in most cases they're going to, be smart about it and not going to post anything racy or something like that. But in the United States, we would look to the parents to make those decisions. In the EU, they look to the state to make those decisions. And, you're right, pushing that button, isn't that inherent consent? I mean, people are coming to you. They push that button. They want to be there. So obviously they understand that. The other strange side of that is, think about, they're saying that you and Facebook are partners. Okay. Well, if you say, hey, partner, we need a consent mechanism here, how quickly do you think Facebook's going to get around to reacting? Years, if they react at all. They even respond to your request, and yet you're going to be held jointly liable. Now, obviously, they're going to go after Facebook, but it gives you kind of an idea of sort of the lunacy of some of the rules. Now, how does all this actually work out in practical situations? Again, if we're dealing with the enforcement agency like the ICO, I'm pretty confident that they wouldn't hold you liable. They would just say, Facebook's got to do this. Or
go for the deeper pockets.
Yeah, and not even so much the deeper pockets, but just that if they can force Facebook to, take some action so that there is an actual legal basis, that will proliferate all the way across Facebook, all the other fan groups. There are other groups out there like Germany where, they'll just find everybody that they can. And unfortunately, that's kind of the risk that's out there. So it reflects kind of a bigger view of the internet. Is it really going to be a worldwide anymore? We're going to see limitations placed on it. We're already seeing limitations. It's just kind of a question of, how far that goes before people start, saying, hey, I wanted to see these websites and I don't really care if, Google puts up 15 ads that, reflect whatever it was I was looking at last night.
Well, I can definitely see that, because of the complexities of these laws that, there are going to be a lot of people that stick their head in the sand and, that's not necessarily the best way to do it. And so I think, for somebody who may be listening and maybe, listening to all the complexities and may be confused about it, or, they have a business or a website or an entity and they want to, jump on a phone call with you or have a consult with you, what's the best way for someone to get a hold of you for them to be able to do that kind of thing?
Sure. You can always get me at SoCalInternetLawyer.com, my website. That's usually the best way to get to me. Email often is the best. I'm often out of the office running around, but I'll be happy to to chat with anybody. Just mention the show, and I'll give you a free consult. The one thing I will say about the GDPR is it can be terrifying when you look at it, in detail. But I think we also need to realize that think how many websites are out there. And, if you're doing decent business, if you're doing 6 or 7 figures or more in revenue, then certainly you should be all over it. If you have some tiny site, I can't advise you to break the law. You should always be complying with the law, but there's a certain scale of potential risk, if you will, of somebody coming after you. I mean, I don't think that they're necessarily going to be. They're going to be more interested in marks. In cases that people are going to recognize. Facebook fine, $5 billion is going to carry a lot more than, Bob's tomato blog fine, 25 grand, and that's just the nature of it. The other thing is there is one of the things you're going to see online everywhere you read that is just wrong is this statement that if you collect one email address from somebody in Europe, you have to comply with the GDPR. That is so fundamentally wrong. I don't even know where to start. I don't know who started saying that, but somebody needs to be slapped upside the head. That is not the way the GDPR works. The GDPR has what's called a territorial scope provision, and it is Article 3. It has a number of factors, but the biggest one is typically that you are offering goods or services, even if for free, to people in the EU. And then there's a number of factors. There's something called the Palmer test, which is a case that was decided under a previous regulation, but the clauses that are looked at basically match what's in the GDPR. And they look at a number of factors. And even the GDPR says you look at a number of factors. Things like, does your website, market in the EU? Do you have international phone numbers? Do you target people in the EU by the use of language? Can people pay for your products or your services with a currency in the EU? There has to be some rational concept here, and people need to back up and think about it. Let's just imagine, there's an antique shop in Hong Kong that's online. You're telling me one person from Germany signs up for their email list, and then that site has to comply with the GDPR? Nah.
That doesn't make sense.
So I think that there is, an aspect of that. Now, if you are selling to the EU, if you're in the U.S. and you're selling, soccer jerseys to the EU or whatever, then you're obviously going to have to get into compliance with it. But I think some of the myths out there about the GDPR are a bit much. So unfortunately.
Make sure that in the show notes that our listeners can find at toughdecisions.net will be with this episode. We'll put links to your website as well as any other way you want them to get a hold of you. That way, if they have some further questions, want to follow up after having this interview here on the podcast, they can do that. Thank you so much for taking some time out of your schedule today, Richard, to be with us today. Look forward to having you on a future episode.
Yeah, thank you for having me on. It was definitely a good time. And yes, in the future, any future legal developments, I'd be happy to pop back on.
Yeah, sounds good. Thanks, Richard.
Thank you.
Bye. Thank you for listening to the Tough Decisions Network. Be sure to visit toughdecisions.net to gain access to show notes for this episode and to join our free weekly entrepreneur email where we will send you news about the latest technology for your business, inspiring quotes, and the latest books for entrepreneurs. That's toughdecisions.net.